Welcome to I'm Pre Kershaw. Alongside of me is Andrew. And today we have a special guest, Seth Meyer. He's an attorney in New York. He is doing service in New York in construction. So today we're sitting with him and we're going to get to know what he does and how he can help your business. I've dealt with him and he has a load of experience that he can bring to your business. So today we're going to be talking to him.
Thanks for having me, Preet and Andrew. I am a construction attorney. I'm a partner at the law firm of Capel, Barnett, Matalone, and Schofield, and we're based in New York City and Syosset, New York. And as Preet mentioned, I am a friend to the construction industry. I work with contractors, subcontractors, and owners in all parts of the construction business, from negotiating contracts to collections of money that are owed, to compliance, to licensing, and everything in between. And my job is to help you stay in business so you can thrive and grow. And nothing makes me happier than watch you build successful businesses like Preet, APC, and her wonderful podcast today.
Thank you, Seth. Seth, so today, we notice a lot of small businesses, they're a little bit nervous with hiring an attorney, basically. They're looking at the costs. Now, I know from my business, hiring an attorney saves you rather than you're looking at the cost. You need legal advice. You need legal help when it comes to contract. That's one of the most important thing that could bring your business down if you don't have a proper contract. What advice you can give the small business out there, to hire an attorney, making sure your contracts are all good so your projects are successful?
Sure. An ounce of prevention is so much better than a pound of cure.
Yeah.
Construction contract between a general contractor and a subcontractor is the lifeblood of the relationship of the project. Whenever there's a problem, everyone is turning to the contract. When a subcontractor is trying to get paid, they're judged by the contract. What the scope of work is the contract. When there's extra work, change orders, or something that doesn't make sense, usually the contract will speak to it. The biggest problem I see are contractors who look at three things: their name, their start date, and the amount they're going to get paid. And once they see those three things, nothing else matters. But when you finish a project and you're waiting for your retainage or their last check, and you see that you have to wait until the whole project is done, you're giving a loan to the upstream contractors to hold on to that retainage money until they're done. So if you're one of the first trades on a job, then you could be waiting years before you see that retainage money back. And that's can potentially choke a business. So having someone look at that contract beforehand so you could have informed discussions with your upstream parties or downstream parties is worth more than its weight in gold, because those are conversations you can have to get money in your pocket today instead of 3 years from now.
It's actually interesting that you bring that up, because there was a situation that even myself I was dealing with where even if the business was a certified veterans MWB and there are laws in place for prompt payment, whether the agency or the municipality that's doing it, I noticed that even going up the ladder and asking for help from some of the diversity departments, that they came back and said, we do believe in the prompt payment system, but you're going to have to check with your contract. We're seeing the same thing in the industry where even though a trade is done and completed 2 years ago, still have to wait 2 or 3 years. And we're talking about thousands, tens of thousands of dollars sometimes.
So the way I like to work with the parties is to say, we all want to work together. We want this job to be completed successfully, on time, potentially under budget. And the best way for us to do that is if we treat each other as equals and with respect. So when you're in that initial stages of when you're bidding a job, you win the bid, and now you get the contract, you guys have an opportunity to have a really frank discussion about your needs as a trade contractor doing the work and their needs as a general contractor or upstream party to make sure they comply with their requirements. Also, what's really important is you're bidding a job based off of a set of plans and some requirements, addendums, and the like. Once you see the contract, there could be other costs hidden in there that you don't expect to incur. Potentially bonding, potentially higher insurance premiums than what you ordinarily provide on a job. So all these are going to impact your bottom line. So when we're looking at a contract, we're looking at opportunities for collaboration, but also opportunities for us to do the job as we bid it or as we intended. So we're not sitting in a position a year or 2 years later saying, I ran out of money, we still have work to do, or general contractors saying you have to do something that you may not have anticipated doing because it's in the contract. So everybody wants to work together, everyone wants to get the job done, but it's about doing it in a respectful and collaborative way.
Correct. And then there is other things in the contract like liquidated damages. That's a big one.
Liquidated damages basically say if you don't finish your work by a certain date or you don't meet certain contractual requirements, they can charge you for those delays. And that can be very damaging to a business because if you're a trade who's down the line and the schedule gets impacted because of things that you had no control over, you don't want to be responsible for those damages. And you want to make sure that you know what your rights are and how to use your rights to make sure you're compensated for those changes, whether it's an extension of the schedule to give you more time to do your work or potentially more compensation because now the pricing that you gave can't hold because it's based on a different project timeline. And generally speaking, the contractor is going to speak to all that. So if you're reviewing that in the beginning, one, you may be able to remove those liquidated damages, or two, if those are going to stay, giving yourself the opportunity to counter some of those provisions with things that could be more favorable to you, like compensation for delays instead of just an extension of time to complete the work. So by thoroughly reviewing the contract and actually going through it, you could save yourself a lot of money, time, and advil costs because you'll have fewer headaches.
What have you seen the industry standard, especially that you're dealing with this every day or making these changes in the beginning? Like, what have you seen in the general consensus of everything?
We all know construction is really tough for everybody, from the subcontractor to the supplier to the general contractor to the project owner. And there's a zillion different ways a construction project could go wrong, from weather, labor, a global pandemic, to really the inability to get material on site. So when those situations happen and the machine isn't working as it's supposed to, it can lead to all sorts of problems. The project schedule gets behind. So now general contractors or upstream parties are asking their lower tiers to rush manpower on the job. But is more manpower really the solution? And that's going to add increased costs to the trade contractor doing the work. How is that going to be compensated? How are we going to deal with those problems? Project got shut down because a change in something led to a funding issue. So now you're off the site. Now you have to come back on the job, or the project funds dry up. What now? So really anything and everything can go wrong on a construction project, which is why these contracts are generally so big and they touch on so many different areas because we just don't know. And the best thing that we can do is review that contract and say, look, these are some and judge the risk. These are situations that are potentially going to happen on our job. We may want to discuss these with the general contractor. These other provisions probably won't impact our trade. So maybe we don't need to discuss these as much. So it's as much a strategy as it is risk tolerance and risk awareness. And, since anything and everything can go wrong, it's on us as the ones doing the work to make sure that we have strong processes in hand, strong communication, and that we're on top of our projects, our requirements, our deliverables, and our obligations. So prevention and being ready in the event of when something goes wrong is just as important as when something does go wrong.
So have you seen any issues lately with the tariffs? Are businesses having issue with the prices that they're paying? Have you seen anything like that?
It's very interesting because, we're coming out of the COVID environment, which also
Correct.
had material and price awareness more so than we had in the past. So with those memories fresh and now the potential impacts from tariffs, it really gave the industry an opportunity to see what worked over the COVID period to what works and doesn't work now. Because you could have general contractors or upstream parties that say, no, we're not going to give you any tolerance for material increases. You bid a job, now complete the job. And what can some of those consequences be? Well, now your trade contractors don't have money to complete, and there's potential completion, termination, or other issues on the job, to an awareness that we may not want to be so firm on this because we'd rather get the job done for a little bit more than we expected than having a subcontractor off site. And now we have to scurry to find someone to do the work, potentially at an even higher cost, and our project schedule is impacted. So there's more recognition of to what potentially could go wrong. I've also seen contractors and upstream parties being very flexible, that the subcontractor will take on some of the risk of the cost increase, but then the general contractor will also take in a piece. So for example, if the price of a certain material goes up 20%, the subcontractor will cover the first 10%, and then the general contractor will cover the next 10%. So it's really about having open relationships and open communication, because you're going to want to keep everyone in the loop as these are happening. You know, everyone reads the news, everyone sees it on TikTok, Instagram, or whatever. Everyone's talking about these issues because it impacts everyone's life. So if we're having an open communication with our upstream partners or downstream partners about where these impacts could be, it lets everyone get ahead of them and potentially negotiate them.
That's a great point. There was something that I was even thinking about just the other day about advising or getting that information out there, that it is okay in your bid or your contract when you're talking and negotiating, communicating, to actually say that after a certain year, and again, I don't know how this would be worded, but after a certain year, if the job site does actually go that long, that the prices of your work, your scope, will increase. Like in 2027, 3.5% or 4% increase due to costs always going up, obviously. So have you seen that as a norm, or is it something where people have to be creative and actually have that communication? Because even when we're discussing it, that's the first time even I've heard of that. And that's something that seems relative, reasonable.
So it's a great question. And as to whether there's a norm, I think there's one norm we can all agree on, is that everyone is looking for cost certainty, right? If someone signs a contract with you today, they want to know that that price is going to be firm today, tomorrow, or whatever the future may hold. So certainly in our bids, I always counsel clients to give the bid an expiration date. Things may change in the next 30 days. Politics and those rules tend to be very fluid, especially in current times. So we have to be in a position to be flexible as needed. I have seen clients, we have tried to negotiate in price escalation clauses for really anything and everything, right? It's a conversation of what are your upstream partners aware of, educating our upstream partners as to the potential issues, concerns, and why it's important to us to see how we can negotiate that. But it really depends on the trade, the client, the trade contractor, and their upstream partners, because some trades are more susceptible than others. Some upstream parties are more collaborative in these areas, some are less. So it's really a combination of how you see yourself, how you see your partner, how you see the job going, and what everyone's tolerance is. And if we negotiate these things in advance as part of the contracting process, then it gives us better insight as to say, well, if we're having trouble with this issue, what's it going to be like when we're actually on the job? Is this somebody that we want to do business with, or perhaps we're better off putting our efforts elsewhere? And, it works both ways, because you see a great upstream partner that says, yes, this makes sense. We want to see you thrive and succeed. And now you're going to gravitate towards them in the future, versus a an upstream partner who may take a different view of it, and you say, look, maybe we have to be more cautious. So it really goes to the potential relationship and how a job is going to get done.
Correct. I always give advice. You need to have good people on your team. You need to have good legal service. You need to have good CPAs. You need to have also good insurance. A lot of small business out there, they don't do that, and then they end up in problem. I try to encourage that because I see the problem, and it's things that could be fixed. But a lot of people don't want to take the leap into getting the correct people. We've seen a lot of things happen. Now, what are some things you've seen in your experience happen, and maybe you had to rescue someone and get involved?
So, to your first point, Preet, you're absolutely right. I think every business, big, small, or in the middle, or whatever they want to be, you need to have your core professionals. And you hit on it. You need to have personally, the most important one. I go to sleep and I wake up thinking this. Your lawyer is the most important part of your team. There's no one more important.
Yeah.
Alternatively, really, your CPA and your insurance professionals are the most important, because without insurance, you're not getting on a job. Without the right insurance, you're not getting out on the job. Without your CPA and your back office team keeping the ducks in a row and the money right, we don't know if we're profitable or not. Your attorney is great for strategy, contract review, and negotiation. And your banker is also going to be a fundamental part of your team, because if you need checks to clear faster, if you need to get a sense of what credit or lines of credit are available, you need to have a strong relationship with your bank. Your banker is someone you want to talk to pretty regularly. Your insurance professional, you're going to be talking with them at least weekly, and your accounting team similarly, and your lawyer. Most clients would say, if I talk to my lawyer, something is wrong. And most lawyers say, please talk to us sooner, because the sooner we know there's a problem, the sooner we can help you find a solution or help you weigh your options. The term lawyer is really two things. It's an attorney and a counselor. And an attorney, you think of, we're running into court, we're saving the day, trying to save the day. But the counselor is more on the day-to-day side. I want to run somebody impartial who has my company's best interest in mind. Let's call the lawyer. The lawyer generally is one step removed from the business. I can't go to a construction site. You don't want me on your site, but you want to talk to me about what's going on with your jobs, so we can work together and say, these seem like potential issues. Let's look at what the contract says. Let's look at what we know can work, and let's get it out of your head and into a plan of action. So a lot of the issues I see are people or potential clients, or anyone really we work with, is we can solve this by ourselves. We don't need anyone else. Or this is going to be too expensive. Or this is something that no one else is going to know, because we're so particular, we're so specialized. This is the first time it's happened to everybody. And what I'll say is this: the sooner you get in people who can help, the sooner we can help, and the worse it will. The prevention is worth its weight in gold. So I would say, get us in there early. Whether it's an accounting problem, get your accountant in there. Whether you're concerned about your insurance, get your insurance person out there. And you'd be surprised how reasonable the cost for a lot of these services can be if you get in there early, because reviewing a contract is significantly cheaper than having to fight over a dispute over a contract.
Oh, yeah.
So, it goes to that ounce of prevention, pound of cure. And, I hate to hog the mic, but a great anecdote is, I was at a networking event recently, and they said, look, what do you do when a potential client isn't going to listen to you? And everybody in their various different businesses talk about how they persuade their client. When it came to me as the lawyer, I said, look, I tend to make more money. I have more cases when people don't listen to that advice earlier, don't attack an issue earlier on. Because when you attack something earlier on, you prevent things from getting out of control, and you can prepare your response in a way that's compliant with the contracts, shows that you're serious, shows that you want to be taken seriously, and it leads to generally can lead to a better resolution sooner instead of dealing with the problem after it happened to resolving a problem earlier on before it happens.
And I've had experience with this, and especially Seth, what you were just talking about, is I think the psychological nature of a lot of small business owners is I know how to do everything, and I'm okay. And sometimes I've seen in real life an owner get chummy with their counterpart, a GC or somebody else. And of course, promises are made. Oh, do a great job on this job. I'll give you more job sites. Hey, lower your price, especially with a lot of subs, lower your price because I'm going to get you more work later on. And then all of a sudden, how you just said, a year later, you're coming in and fixing the issues where it was in the beginning. The way that business works well is when things are on paper, black and
Correct.
white.
Yes.
And most of the time, a lot of small business owners say, oh, I can do everything. I can do my accounting. I can do my legal. I can run the job site. But that's not the case.
It's a very delicate balance because most small business and most business generally are based on relationships. It's two people getting together over a cup of coffee or something a lot stronger and saying, we should work together and this is how we can do it fairly for everyone that makes sense. And the best intentions leave that table and go to the respective offices where we say we're going to have a job together, we're going to do it. And people who potentially weren't at that lunch, that powwow, are creating the contract or creating the rules of the engagement, and things are a little bit different. And it could be from the best of intentions. A company or general contractor has one contract that they use for everybody. That doesn't necessarily capture what happened in your discussions. So we need to review it to make sure it makes sense. And if it's not going to be the attorney, at least have someone who wasn't at the discussion review it to say, I know you came back from the meeting saying you were going to get paid X per square foot, but this says Y per square foot. And when you take in the insurance costs and they threw in a performance bond requirement, that's like half of what we thought it was. You may want to go have a conversation with somebody. So and the more times than not, it's not because anyone's trying to pull the wool over anyone's eyes, right? It's people who weren't there are involved in the process. And to that end, reputation is everything. You're going to want to be able to have another lunch with that person to work together again. So everyone just wants to make sure that the rules of the game, the rules of your understanding are followed, because if something goes south, you're going to turn to your colleague who said, look, we can get you this job at this price. And you're going to look at them and say, what happened here? And nobody wants that relationship to sour. So it's trust and verify. It's let's have those great relationships. Let's use those relationships to grow our business, but we still have to protect ourselves because it's our business. Because at the end of the day, your colleague is looking out for their business. You're looking out for your business. And if everyone's doing that, then we have a relationship based on trust and continued growth. And then you can have more fancy cocktails and get more work done and really grow that momentum together. But it's always important to have that impartial person who wasn't there take a look at everything to make sure it actually meets with what you want to do.
Correct. You're right about that. And we do see it on a day-to-day basis. There's only so much you can do at that point. So it's better to be prepared rather than you're sitting there waiting. And then you're going to make a decision when you're like neck and neck. So what do you do? So that's a terrible situation. You never want to be caught in that situation at all. So besides contract reviews, what else services do you provide?
Sure. So a lot of my day-to-day is contracts and counseling clients while they're on jobs where they may have potential cost increases or change conditions or change schedule. And they want to make sure that they're complying with their contract, whether it's sending in notices or attending a certain meeting or following a certain procedure to get what they want. But the other part of my business, my practice, is what happens when the contractual relationship go south, or there's a disagreement over what everyone was supposed to do under the agreement. And in those situations, I will take those cases to court to advocate for my clients and to uh, push through the interpretation that we believe is correct. And that takes many facets. One of the parts of the construction contract that only the lawyers get excited for is called the dispute resolution section. And that talks about what happens if there's a disagreement, what do we do? And it ranges from, well, the principals of the company have to talk and try to resolve it together, which I always think is a great idea.
Yep.
The architect comes in and makes a determination. Okay. Then there are more formal processes like mediation, which is where each side goes before an independent third person and they talk about what their position is, why they think they're entitled to a certain amount of money or not. And the mediator tends to do one of two things. One, they try to get everyone to a deal, right? It's, for the most part, we're dealing with money here. We're not necessarily dealing with civil rights, human rights, or, it's a commercial contract. It's two people who are coming together, two companies, to do business and hopefully make money off with one another. And if that fails, hopefully the mediator can say, look, this is a reasonable amount of money for this, minimizes your downside, and you can go on and continue your business. Or two, you'll get a mediator who says, your side, APC is probably correct. General contractor, you may want to think about how you're treating APC here, because this could potentially not resolve in your favor and could cost everyone a lot more, and including what APC could receive. So that's another step, and a lot of cases resolve that way. If that fails, then there's the real dispute resolution, going to court, arbitration. So really, all that's going to be laid out in your contract. And a lot of times I spend counseling clients how to prepare if things can't be resolved amicably and early on. And if, going back to our earlier discussion, if we bring in if you bring in your attorney earlier into those conversations, they can help you build the evidence, make items more favorable to you. You get an email from an upstream partner that really doesn't make a whole lot of sense. We can help you craft that response. So in 2 years, if you're before a mediator or an arbitrator or a judge, you can say, look, we received this email from somebody else. It didn't really make sense. This is how we responded by referencing the contract, talking about what happened and supplying our proof. And now your record is made 2 years earlier when you had your team involved. So a lot of what I do is dispute prevention, dispute resolution, and helping clients get into the spot where, should there be a dispute, where we have our ducks in a row early on.
That's very important.
Well, what I see as a key thing, and especially what you just said, and this may not be known to most people, is that mediation, even though it could be in your contract, mediation still has a cost.
Of course.
If you're going about this saying, okay, no problem, I don't have to bring in a lawyer in the beginning, and then, I have a mediation clause. Doesn't that mediation clause could actually cost each side thousands upon thousands of dollars to actually have the mediation? And so now, especially everything that you said, Seth, if these things were taken care of in the beginning and everything was, agreed and in black and white, then there's less of a chance, especially having that open communication, having less of a chance of getting to that route, because it'll save money in the long run.
Correct.
Sure. During the mediation process, you're paying the mediator. Usually each side pays half. You're going to be paying your legal counsel to be with you at the mediation. But the most important cost those are the hard costs. Those are the costs that are going to come out of your pocket. The true cost is, I have to spend a half a day with my attorney preparing for the mediation. So now I'm not bidding on work. Now I'm not going out to those lunches to develop those relationships. And now I'm not inspecting my job sites to make sure things are moving properly. So I've already lost a half a day, potentially more. I have some of my back office team members getting records, going back into history to find what happened here, or I'm doing it at 11 o'clock at night when I'd rather be sleeping or doing literally anything else. And then I have to spend probably a whole day with my lawyer who I'm paying, and I'm basically out of pocket the whole day, and I'm not moving my business forward. So these are the hard costs that are going to be in the construction contract, and the potential soft costs of engaging in the dispute resolution process. So while you're negotiating and while you're reviewing that contract, these are items that I like to point out early on. And they help inform the client as to, going back, what's the true cost of this contract, and will I make the money that I think I'm going to make here?
Interesting. See, this is the reason why you bring people in early.
So we're going to have episode 2, and we're going to share more on how to protect your business on part 2. Thank you for joining us, and we'll see you in part 2.